Good afternoon, everyone. Welcome to the second part of this particular day's session, that is on case analysis and legal journalism. Please let me know once my screen is visible to you all. Is my screen visible?
Yes, ma'am, your screen is visible.
Great, thank you so much. Let's begin. The session basically is on case analysis and legal journalism. Now, the introduction. So, case analysis is basically a method by which we, that is the people of legal profession, examine and try to interpret the court's decision. What we do in this is that we break down the particular case into various stages, including the facts of the case, the history, the background, and what are the implications, what were each party's contentions, what were the legal precedents that were cited, the applicable law, and finally what was the judgment and what is our analysis. So case analysis basically is interconnected to legal journalism in various ways. Firstly, because in both legal journalism and case analysis, what we do is that we I'm audible.
Yes, ma'am, you
Okay.
are audible.
Thank you. Basically, legal case analysis and legal journalism are the topics that are integrally connected, because in legal journalism, also what we do is that we report on various case laws that are uh, or the case judgments that have been given by the various subordinate courts and the high courts and the Supreme Court of the particular countries, and we try to understand the legislative developments for a broad audience, and this includes the general public, legal professional, and obviously the policymakers as well. In both legal case analysis and legal journalism, we break down the cases or the orders given by the honorable courts into various parts, and then we try to explain it to the people. So, coming to the importance of both legal journalism and case analysis, the first is understanding the legal principles. Now, when you do legal journalism or case analysis, it helps in understanding of fundamental legal principles and the doctrines of law. Now, what we do in this is that we study the legal precedents, the so while writing our case laws. So, by studying this past cases or legal precedents, we can understand the application of legal principles and how they have evolved over time. And this understanding is really essential for us. And why is that? That is because it helps us interpret laws correctly, and it helps us apply them in the upcoming cases or in the new cases. The second is identifying precedents. Precedents, or also known as the court's earlier judgments of prior decisions, are critical and very common in all the legal systems. So when you do case analysis or when you do legal journalism, what it does is that it allows you to identify relevant precedents that can support your argument. And precedents are really important because they help ensure that there are similar decisions in similar cases, and this promotes the stability in the legal system and promotes the fairness as well. Then third is clarifying court's reasoning. Analyzing cases, which you do in legal journalism while you write the conclusion and you doing case analysis, it helps you clarify the reasoning behind the court's decision. It helps you understand the rationale that is used by judges, and it provides insights into why and how the decisions were made. Then there is educating law students and professionals. Now, both legal journalism and case analysis helps you be updated with the law, and it is a foundational aspect of law, because by examining real life cases, all the law students and professionals relating to the field of law, they learn more critically, and we understand the legal principles better, and we understand how the theory that we learn in our colleges and universities are applied in the practical world. Then we have supporting legal arguments. So in legal practice, while once you start practicing, whether you go into judiciary or whether you go into litigation, in legal practice, you'll always find that if you want to write good arguments, you need to understand the previous case laws and you need to rely on them. So analyzing cases provides the necessary supports for legal arguments by referencing established judicial principles, and it helps build a stronger case. And once you read these particular decisions now, once you try to analyze and work on them now, you'll have a what do you say you'll have this particular cases in mind. So whenever you start practicing, or if you already are practicing, they will definitely help you. Then enhancing legal writing requires precision, clarity and persuasiveness. So when you do legal journalism and when you do case analysis, you I'm so sorry. Yeah, when you analyze cases for your legal journalism and legal analysis, it helps you understand how to write a well structured and well reasoned legal document, such as briefs, opinions, and memos. Then informing public and policy debates. So both legal journalism and legal case analysis helps informing the public and policy debates by providing legal perspective on a current issue. You might have seen that many a times the news that is published on websites such as Barbench or Live Law. These have started some debates between the policymakers, between the students of law, and between the public as well. So when you provide a legal case analysis and you do legal journalism, it gives a perspective to those particular cases. Then is critical analysis. So case analysis and legal journalism involves critical thinking and analysis. Legal professionals, what we do is we evaluate the merits of different arguments, assess the strength of the evidence that was presented, and determine the relevance of legal principle. This is I'm so sorry. This critical analysis is essential for effective legal reasoning and problem solving, which is one of the skills that you'll require when you start litigating. Then there is ensuring consistency. Now, consistency in legal decision is vital in maintaining public trust in legal system. Case analysis, when you do it, helps ensure that similar cases are treated similarly, because you cite previous precedents relating to a similar case that were mentioned by the arguments done by the petitioner or the respondents, and that helps the courts in making their decision. And when you mention them in a case analysis, it helps the reader, whether it is a student, whether it is a professional, whether it is normal public, or the general public who are not related to law. It helps them understand that yes, the judiciary is fair and there is consistency in what we do. Then is highlighting implications. Analyzing analyzing cases highlights the broader implications of legal decisions. This includes the impact on society, individuals, and legal systems itself. So, once you write a legal journalism article or once you do a case analysis, you can see what are the broader implications of the particular judgment. And that is something that is highlighted in the case analysis. Then we have parts. Now, these parts are common for both legal journalism and case analysis. The first is the introductory part, the second are the facts, then we have the issues and contentions, the judgment, and the analysis. Coming to the introductory part. Now, the introductory part includes the case title, the citation, and the court name. Case title is very simple. There's always a case between X versus Y. That is, there's one party versus the other party. You'll have to mention their name, then the citation, and the name of the court. Say, for example, the case is in the Supreme Court of India. You'll have to mention the Supreme Court of India. This is the introductory part of the case. Then we have the facts of the case. Now, both in legal journalism and in legal case analysis, we write the facts of the case so that the person understand why a particular, what is the issue at hand, what was the dispute about, and why the particular judgment has come. So in facts of the case, first we have the nature of litigation, then the parties involved, then the cause of action, the relevant laws or keywords, and the previous court's decision. So, in the nature of litigation, you briefly describe what is the kind of case. Say, for example, it is a property dispute. You describe the property dispute. You describe that it is a dispute between two neighbors relating to a common path, or who does it belong to. Then the parties involved, that is the plaintiff and defendant. You explain who the plaintiff is and who the defendant is. Then the cause of action, that is why, what was the reason that the case was brought before the courts? What was the reason for the dispute? That is what you write in the cause of action. And then relevant laws or keywords, that is the important legal terms and statutes that are being used. Say, for example, my case relates to the Transfer of Property Act, then I'll write the TP Act of whatever year that is. If it relates to the Constitution of India, I'll write the Constitution of India. If my judgment also has parts of specific performance, then I'll write specific performance. So whatever are the laws that are related, those all I'll mention in my particular fact. Then previous court's decision. If it is an appeal, if it has gone to the Honorable Supreme Courts or High Courts, then and it is an appeal. If it is an appeal, then you'll have to mention what was the subordinate court's decision, whether the court gave the decision in favor of plaintiff or defendant, and what was their reasoning. That is also something that you need to mention in your facts. Then we have the issues and contentions. So, firstly, you need to identify what the key issues are. Usually, in case analysis and legal journalism, also what you will see is when you're reading a court's order or the judgment, if it is a judgment, specifically the issues will be written. If it is an order, sometimes the issue might be written, sometimes the issue might not be written. So, if it is a judgment, you'll definitely find an issue. If it is an order that you're doing legal journalism on, then you might have a little bit of problem finding what the issue are. So what you need to do is you need to read the whole order in a good manner, and then you need to try to understand what is the court's decision. Once you try to understand what the court's decision is, then you will see what the question is, right? It'll automatically come into your brain why the court has given this particular decision, and what the question was before the honorable court, or what the facts were before, or what the issues were before the court. Say, for example, if it is for a breach of contract, then you'll have to write that the question was whether the defendant had performed the breach of contract or not. So you'll have to write that the defendant breached the contract. Also, remember that the issues that you write are general and related to law. They're not fact specific. The issues are never fact specific. The answers might have the facts. That is, the contentions that you mentioned of the plaintiff and defendant might have the facts, but when you're writing the issues are general and concise. They're never fact specific. Then after issue comes the contentions part. So in the contentions, first you write the arguments that were made by the plaintiff, then you write arguments that were made by the defendant, and if there were any combined decisions, any combined contentions. That is, both the plaintiff and defendant, if they had said something with together, or if they had grouped opposing a contention together for clarity, then you have to mention that as well. So issues are the main legal questions that the court has decided on. They're concise and general, and they are not fact specific. And then there are the arguments presented by the plaintiff, arguments presented by the defendant, and then there is the combined group contentions, if there are any. You'll find combined group decision mostly in suo motu cases taken by the Supreme Court or the High Court, or you'll see combined group decisions mostly in the higher court cases only. There is a rare chance you'll find these combined group combined contentions, or combined arguments in the subordinate court's decisions. Now, the last part is the judgment. Judgment is the most important part of the case, and it has the court's decision, the remedy that was granted. If it is an appellate decision, then what was their decision? And then there's the concurring opinion, dissenting opinion, and a summary. So, the court's decision, say for example, it is a property dispute. So, what was the outcome of the case? Say the outcome of the case was that the case was decided in favor of the plaintiff and he was given a cost of XYZ rupees. So, you'll have to write that the court gave a judgment or an order in favor of the plaintiff and granted so and so cost to the plaintiff for XYZ reason. Then, if there are any other specific remedies except costs, if there is any other specific performance that the defendant needs to do, or if there is anything else that the court cited in the favor of plaintiff, that is also to be mentioned. Then, appeal its decision. Now, if the case has went in an appeal to the Supreme Court or to the High Court, then you'll also have to write whether the lower court's decision was affirmed, that is, whether the High Court or Supreme Court said that the lower court has given the accurate decision, or whether the decision was reversed, that is, the court said that no, the decision given by the subordinate court was wrong, and we find XYZ thing, and hence we are giving that, or whether the decision was remanded, that is, whether it was half, partly accepted and partly not accepted, and what part was not accepted and why it was not accepted, that is also something that you need to write. Then there are concurring opinions and dissenting opinions that needs to be mentioned. Now, say for example, the bench that is presided in a particular case is of 7 judges. Out of 7, 6 have given the decision in favor and 1 has gone against. So the judge that disagrees with the majority decision gives his dissent, and his opinion is known as the dissenting opinion. So when there's a dissenting opinion, what is the judge's reason behind disagreeing to the majority's decision is something that you need to write. Then the concept of concurring opinion. Say, for example, the 6 judges that have agreed with each other have, or the 6 judges that have decided in favor. Now, out of 6, 2 judges have decided for X reason, 2 have decided for Y reason, and 2 have decided for Z reason, but the outcome is the same. What were their reasons for deciding in favor of the plaintiff? That is something that you need to write. Then there is summary. Summary is that after writing all these things, that is the court's decision, the remedies granted, or if there is an appellate decision, whether it was remanded, reversed, or affirmed, and the concurring and dissent opinion, you'll have to write a conclusion of what you have understood in brief just about this particular judgment. It does not include the facts, it does not include the contentions, it does not include the issues. It just includes the judgment part, which you'll have to write it in short, summarizing the whole decision. Then there's the analysis part. Now, in the analysis part, the first thing that you have to write is the significance of the case, that is the importance and impact of the case. Now, this analysis starts with identifying why the case is crucial. For example, it may address an important legal question that has never been considered before the court, or it might resolve a conflict that has been going on between the decision given by various courts on the same topic, or it is bringing clarity and consistency to the law. So that is something that you need to see. So if your case is bringing any clarity or consistency, if your case has, addressed a question that has never been addressed before, or if it is resolving a conflicting decision from lower courts, then those are some points that you need to mention in your analysis. Then the case's impact can be profound and it can be leading to changes in the existing law. Many a times you'll see Supreme Court's judgments where they have said, so say for example, there is the of Vishakha, right? So in the Vishakha judgment, there were certain guidelines given, Vishakha guidelines. Now that was one of the basis of the POSH Act of 2013. So if your case has, in some way affected the policy making, or if it has impacted the decision making, or if it has become a basis of creation of new laws, you'll have to mention that as well. Then the relationship to other cases in which you compare it with similar cases. Now, what you do in this is that you look at previous cases with similar facts or similar legal issues and identify both the similarities and differences. This, when you do this comparison, it helps reveal how the precedents have influenced our current case, whether the court may have followed it, or whether the court may have deviated from this particular thing. By examining how the case fits into the broader landscape of judicial decisions, we give insights into how the laws are changing, how the interpretations of law are changing day by day. Then there is the historical context in which we write the case's place in legal history. Now, this might include examining the prevailing legal doctrines, the political climate of the country, and the social attitudes of people relating to the judiciary. I'm so sorry. Uh, when you understand the historical context of the case, it reveals why the case was decided in the way it was and how it fits into our present world, and and whether it would fit in the future as well or not. Because law, we know, is something dynamic. What we feel is right today might not be right tomorrow as well. It is not necessary that both the things can happen, right? Either what we decided 20 years ago can be applicable 20 years later as well, or either what we decided 20 years ago will decide something completely opposite 20 years later. Because laws change with people, and the interpretation of laws change with people as well. So in the historical context, what is the case's place in today's world? You'll have to write that as well. Then the court's decision making, in which you write the insights into judicial reasoning and processes. So when you write about court's decision making, you include uh, you look at the legal principles and doctrines that the court has applied, and how it has interpreted various statutes and constitutional provisions, and the logical structure of the arguments that were presented by the parties, that is the petitioner and the argument. And then you try to see how the court has understood their arguments and how they've based their decision on the plaintiff's arguments or the defendant's arguments. So that is something that you need to understand and write in your analysis part. Then the impact. What impact did the court's decision have on the litigants, that is the parties who were parties to the case, then the government and the society? So say for example, it was in favor of the plaintiff. So what relief was granted? How does it impact society? Say there are many similar cases that are going on. So one can say that this case sets as an effective precedent for all future cases relating to XYZ topic. And how does it impact the government? Now, say for example, it is the Vishaka judgment. Vishaka judgment definitely had impacted the government at that time, and also the legislature who was making the law. So, how did the judgment impact the government and the society? And say, for example, the women. What was its impact, and what was its impact on the litigants? That also is something that you need to write in short. And then the evaluation part, that is assess the rightness and logic of the decision. All the above mentioned 5 points, that is the significance, the relationship, the historical context, understanding the court's decision making and impact, are something that are more theoretical, and that is something that you do not have to apply your own mind to. You know it, you write it. But when it comes to the evaluation part, that is assessing the rightness This is completely upon one's perspective. What I think is right might not be right for others, because in a particular case, one loses, one wins. I might think that the judgment was against, what the judgment should have been in favor of defendant, while you might think no, the judgment is correct. So try to understand what was the judge's reasoning behind the case, and then try to assess whether the court has given the right decision or not, or if the court has, uh, you know, left out some particular aspect of a decision, or the court has, uh, ignored some loopholes or some gaps in the findings that were given, or the submissions that were done by the plaintiff and the defendant. You have to highlight all those parts while you're evaluating, and write the rightness of the decision. And you'll also have to see whether the court has applied its mind in the correct manner or not while you're doing case analysis. Now, evaluating doesn't mean you criticize the judges or you criticize the court. No, we're not saying that you criticize them, but you try to explain that there are certain points that should have also been considered while giving their judgment, and you write down those points. So this is one of the most important parts, and the last parts that you do in legal journalism and case analysis. That is, you understand the significance of the case and its relationship to other cases, and examine the historical context of the case and evaluate. These are some of the parts of the legal case analysis and legal journalism. This session was taken together because legal journalism is done exactly how you do legal case analysis. The only difference is that in legal journalism, we also analyze orders given by the court, while in legal case analysis, you analyze mostly the judgments given by the court. So, if anyone now has any query, please do let me know and I'll answer them. Does anyone have any query relating to legal journalism or case analysis, or the previous session, if any one of you has attended?
You guys unmute yourself and ask.
About how do you get details about the case? Once you have the judgment at hand, you need to read it meticulously. Now, if you read it just once or twice, it won't help. I'll also share another PPT with you guys where we have written what are the steps you need to do. So once you have the case, read it once and twice to understand what were the facts, what were the contentions given. Usually, the good thing now that is happening nowadays is that the facts and the judgments, the facts, the contentions, everything are being separated. So you might not have to do so much. You might not have to go through so much trouble at all if you're given that particular case. But if they are not separated, then also if you read it once, twice, you go through it, you'll be able to understand what you need to do, where the cases are, and what the contentions are, what the facts are easily. You don't have to worry. The order usually is that at the topmost, the facts are written. Then just below that, there are the contentions in the coming paragraphs. And after the contentions, there is the court analysis of what the court understood of the particular case. And then at the end, there's the decision of the court. So this is the style that is followed while judgment writing. And the with citation style is to be followed. Yes, you'll get a sample PDF, and the citation style is Harvard Blue Book 21st edition. And the cases, I believe the team has already replied. It will be allotted by today. No, there's no word limitation. However, you need to write it in enough words so as the person who's reading it can understand it. Now, when you talk about case analysis, what we suggest is you write at least a minimum of 1,000 words because that is something that works. But yeah, 1,000 words around is fine. 800 to 1,000 words. That is something you can do. See, the main difference between legal journalism and legal case analysis, I'd say, is that how you write your particular work. So in legal case journalism, you have, a particular court order or judgment that has been given today. You write it in a, I'd say, shorter manner, but and you explain the details. Whereas in legal case analysis, you explain each and every aspect of the particular case. And however, when you write legal journalism, you can just skip to the facts and then to the judgment. There's no need to write contentions. Completely depending on what you want to do. And the starting points basically. Can you please tell from where you joined so that we can see what we can do? We also have the recorded video, so I don't believe there must be an issue. But if you do have any doubt, again, you can reach to your internship coordinator and they'll help you. And yeah, as I was saying, legal journalism, say for example, today the court has ordered that the electoral bond scheme is unconstitutional. You can do two things. You can do the case analysis on that, and you can do legal journalism. If you are someone who has been given this particular case for case analysis, you'll write the case in a very explanatory manner. You'll explain each and every aspect of it. But if you're someone who's chosen legal journalism, you'll just explain the court's decision and what the judgment was. Does anyone have any other query?
Anyone have any query? Kindly ask.
Photo for testimony means you have to submit your photograph either in formals or whatever photo you want. That will be attached if you want us to publish your testimony. And okay, so Vinny, since you have chosen legal journalism, say for example, you open bar and bench today, okay, and you see a news that you like. What you'll have to do is you'll have to go to the court's order. Because every news platform, whatever they attach the court's order, right? So go to the court's order, read that order, analyze what the judgment is, and then write it down in your own words. That is legal journalism. Legal journalism basically relates to a current case. That is, if example, there's a judgment that was given 2 to 3 hours ago. You analyze that. Case analysis can be done of any previous judgments or any current judgments depending on what are assigned. In legal journalism, you choose the case or you choose the topic that you want to write on and you write on that and submit it in the very same day.